Are you prepared for the future? Have you ever thought about what will happen to your assets and legacy after you're gone? Who will take care of your loved ones? If you're curious about these types of questions, stick around because in today's episode, I will discuss the critical decision between wills and trusts and which one is right for your family to secure their well-being even when you're no longer here for them. Hi, I'm Cindy Kang, founder of CMK Law Group. I'm an estate planning and business attorney in California, and I help families with their estate planning needs. I also support entrepreneurs with their business formations and business law requirements. In this episode, we will discuss wills and trusts, break down each option, explore their advantages and disadvantages, and determine the best choice to safeguard your assets and provide for your loved ones. A will is a legal document that outlines your wishes regarding the distribution of your assets and the care of your dependents after your passing. It's like a roadmap for your loved ones to follow when you're no longer around. Wills offer simplicity and flexibility, making them accessible to many individuals. They're relatively easy and inexpensive to create, allowing you to update or revise them as needed. However, wills must go through probate court. And if you're interested to know more about probate, I discussed it in our previous video. So let's talk about different types of wills that are accepted here in California. Attested wills are considered the preferred type of will under California law. These wills are prepared by your attorney who possesses a thorough understanding of California state law. Upon completion, you must sign the will in the presence of 2 or more witnesses. It's important to note that neither witness can be a beneficiary under your will. If witnesses sign under penalty of perjury, or if you have your will notarized, it becomes self-proving. Self-proving wills are viewed as more valid by probate courts and are less likely to be questioned for their authenticity. Statutory wills are standardized forms created in accordance with California law. These templates can streamline the process for those unsure of what to include in their will. Like attested wills, statutory wills require signing in the presence of 2 neutral witnesses. You also have the option to make your statutory will self-proving. Holographic wills are handwritten wills. While you are not required to sign this will in front of witnesses, you must personally handwrite the entire will. It is advisable to appoint someone who can either provide examples of your handwriting or testify that the will is indeed in your handwriting. Otherwise, the probate court may not accept the will as valid. A trust is a legal arrangement where a trustee holds and manages assets on behalf of beneficiaries, according to the terms specified in the trust document. Unlike wills, trusts take effect immediately and can continue to operate after your passing. It offers several advantages, including avoiding probate and maintaining privacy. By transferring assets into a trust, you can ensure a smoother transition of your estate to your beneficiaries, bypassing the probate process altogether. Trusts also provide greater control over asset distribution and can offer protection from creditors and legal challenges. However, trusts can be more complex to set up and administer, requiring ongoing management and potentially higher costs. There are 2 main types of trusts, namely revocable living trusts and the irrevocable trust. So a revocable living trust, also known as an RLT, allows you to retain control over your assets during your lifetime while specifying how they should be managed and distributed after your passing. You can amend or revoke the trust at any time during your lifetime, making it a very flexible estate planning tool. This is the type of trust that is most commonly used in estate planning where there isn't a federal estate tax concern. Then there's the irrevocable trust. Once established, an irrevocable trust cannot be modified or revoked. Assets placed in an irrevocable trust no longer are considered part of your estate, offering potential tax benefits and creditor protection. However, you give up control over these assets once transferred into the irrevocable trust. These trusts are typically used in more complex estate plans where federal estate taxes are involved. Irrevocable trusts are typically used in various estate planning scenarios where the trust maker, who's the person establishing the trust, wants to achieve certain specific objectives that revocable trusts cannot fulfill. Some situations where irrevocable irrevocable trusts are used include estate tax planning. So irrevocable trusts are often used to minimize estate taxes by removing the assets from the trust maker's taxable estate. By transferring assets into an irrevocable trust maker gives up ownership and control over the assets, thereby reducing their taxable estate. Asset protection is another area where people use irrevocable trusts to shield assets from potential creditors, lawsuits, and other potential threats. Since the grantor or the trust maker no longer owns the assets once it's in an irrevocable trust, they're generally protected from claims against the trust maker's personal liability. Medicaid planning is another area where irrevocable trusts are used in order to help individuals qualify for Medicaid benefits while preserving assets for their beneficiaries. Assets transferred into an irrevocable trust are typically not counted for Medicaid eligibility purposes after a certain period of time after the transfer. Charitable giving, so there's also charitable remainder trusts and charitable lead trusts, which are types of irrevocable trusts that allow individuals to support charitable causes while also receiving certain tax benefits. These trusts can provide income to beneficiaries for a specified period before the remaining assets are distributed to the charity. Special needs planning is another area where irrevocable trusts are used in order to provide ongoing care and support for individuals with disabilities without jeopardizing their eligibility to continue receiving government benefits, such as Medicaid and Supplemental Security Income, or SSI. So that's about what we have to describe irrevocable trusts. And now that you have a very basic understanding of the difference of wills, and then trusts, including the differences between an irrevocable and revocable trust, let's weigh in on the options to determine which may be the best choice for you and your family. So when deciding between wills and trusts, it's essential to cover or to consider various factors to determine which best suits you. So wills offer simplicity and flexibility, making them accessible. They're easy and relatively inexpensive, allowing you to update them, but they do require probate, which becomes public record, potentially exposing your family's financial information to anyone who wants to look at it. It's also, in California, probate is very expensive. The fees alone range from 2 to 7% of the estate amount. So that amount to a huge dollar amount for many families. They'd rather have their assets go to their families rather than to the court system. Probate also takes a very long time. It takes anywhere from 18 months to 24 months. So during that time when the probate process is going, your assets are essentially frozen, meaning that your loved ones are unable to access those funds to survive and live off of. On the other hand, trusts offer a lot of advantages over wills. It's I've heard it described as a souped up will or will on steroids. It has all the benefits of a will, but doesn't have all the downsides since it avoids probate. One key benefit is that there's also faster distribution of assets since you don't have the long probate period, so that your beneficiaries and your loved ones can access those funds right away within weeks, not potentially years. And also you maintain privacy throughout your life and after your passing. Trusts also provide greater control over how and when your assets are distributed, which can be beneficial if you have specific wishes or concerns about how your assets may be managed. For example, you may not want all of your assets going outright to your children when they turn 18, which is what would happen if you just had a will. However, it's important to note that trusts can be more complex to establish compared to wills because they do require careful drafting and funding, and some ongoing administration may be necessary. Additionally, not all assets may be suitable in a trust, and there may be some ongoing costs just to maintain the trust to make sure that the trust document reflects the current situation of your life. Ultimately, the decision between a will and a trust depends on your individual circumstances, including your financial situation, your family dynamics, and estate planning goals. Consulting with an experienced licensed estate planning attorney can provide personalized guidance tailored to your specific needs and circumstances. An attorney can help you understand the implications of each option and assist you in crafting a comprehensive estate plan that meets your objectives and actually works when you and your family need it most. So if you're based in California, you can contact us at CMK Law Group through the link in the description box below for personalized assistance with your estate planning needs. Remember, the choice between a will and a trust is a significant decision that can impact your family's financial security and peace of mind. Please make sure to like this video and subscribe for more videos on estate planning and small business law tips. Thanks for watching.